Welcome, everybody, to Tokens of Wisdom. I'm your host, Dave Rothschild, and today I am delighted to be joined by SEC Commissioner Hester Peirce. Before we dive into the discussion, please listen to the disclaimer at the end of the show. Nothing I say here or Commissioner Peirce says is legal, investment, or tax advice. Commissioner Peirce, thank you so much for joining us today.
Dave, thanks for having me. I do want to start out with my own special disclaimer, which is that my views are my own views as a commissioner, not necessarily those of the SEC or my fellow commissioners.
Of course. Thank you for that. Now, I wanted to start today's discussion by talking about regulation broadly. And I've long appreciated your thoughtful approach to regulation and your ability to articulate your rationales with a fun rhetorical flourish. You recently compared the state of U.S. crypto regulation to one of my kids' favorite games, which is, of course, The Floor is Lava. And I found that analogy illuminating, precise, and a bit more lighthearted than the analogy I like to use, where I compare the regulatory uncertainty plaguing crypto to a zombie apocalypse and the climb to clarity as requiring 3 big steps up the proverbial regulatory ladder. See, in my view, I see regulation as coming in 3 levels, and the higher you climb, the more clarity is achieved. The first level that I see is informal commission guidance, enforcement priorities, informal statements, and the tone of its public communications. I call this the vibes layer, for lack of a better term. The next step up from there is formal rulemaking that would go through the notice and comment process and create more clear rules of the road. And then the top layer of this ladder, of course, is new legislation that would clearly answer some of the fundamental questions specific to this crypto asset class. Now, over the first half of 2025, we have seen a tremendous shift in the Commission's approach to crypto, from dropping high-profile enforcement actions to the meme coin statement to holding a series of crypto roundtables. To me, it's clear that we've reached the first rung of this ladder, that the vibes have shifted. And I wanted to understand from you, how has this happened so quickly?
Well, I really like that that framing of it. I think that the vibes definitely have shifted, and that was one of the things that we thought was really important right away, because during the last 4 years, there really was an approach that was taken that was, I think, very hostile toward an industry. And I think whatever you think of crypto, it really doesn't matter when you're thinking about what should the government's approach be, right? We should apply the law, and we should do the same things that we would do with respect to other industry participants that are running into something in the securities laws maybe that doesn't work quite right. We make adjustments, and where there's lack of clarity, we provide guidance. We should have that same view with respect to crypto. And so when Acting Chairman Ueda came in and said, Hester, I want you to take over the crypto issue, the crypto task force, part of what I wanted to do is really change the messaging coming out of the agency to say, we are definitely wanting to talk to people. We understand that there are areas where the current regulatory framework just doesn't make sense. And it is not actually an effective way to serve the American public to just say, we're not going to help the industry figure out how to make it make sense. Because what we ended up with during the last 4 years, I think, was an approach that really centered around trying to do everything through enforcement, which meant it actually became much more difficult for us and the American public to identify the bad actors. And so I want to get to a place where we have clarity, where the good actors can figure out what they need to do, and it will become much easier for us and others to identify the bad actors. And because I knew I had been talking to people in the crypto industry for a long time, and I knew how negative the perceptions of the SEC were in the crypto world. And so I think it really is important for us to say to people, we understand that the agency has not behaved the way it should have, and we want to take this new opportunity to really get a fresh start. And that does necessitate us having conversations with people who are interested in the asset class, and frankly, people who are skeptical as well. We want to talk to everyone. And so I think that really was why that vibe layer was so important and why it was so easy to turn it around because again, I had been having these conversations for so long that I had a good sense that people were willing to work with us in good faith.
That makes a lot of sense. And so it sounds almost like when you were put in charge of the crypto task force, maybe you had, based on your past experience, you had I'm assuming maybe a list of things that you knew that was within the commission's power to change, more or less unilaterally. I'm thinking things like repealing SAB 121, some of the enforcement actions being dropped, things like that, and that you were able to kind of punch through that hit list pretty quickly.
Yeah, I mean, there's definitely still more to be done. It's not a short list, but yes, there were things that I knew that we could do right away. And one of the things that I had hoped that the prior SEC would have done is just even where we were seeing a lot of activity in a particular area in the crypto space, that we would come out and tell people how we were thinking about it or how the staff was thinking about it. And so some of those guidance documents sort of came from that view that if we're seeing something, we should try to say something as soon as we can.
Do you think the meme coin statement that was released falls into that camp? Is that how that came to be?
It does, and I think that's something where there was a lot of interest in meme coins, and we wanted to tell people. I thought it was important, to give the staff's view that much of this activity is actually not within our space. I think that's important for people to understand that they're not getting the protections of the securities laws. Now, obviously, you can take lots of things that are not securities and you can sell them in a way that they are securities. And so we always have that qualifying lawyerly language. It does depend on the facts and circumstances. And that's really important for people to remember. I mean, the fact that the vibe has changed does not mean that anything goes. When there's activity in our space, we're going to be looking at it closely.
Yeah, that makes sense. I mean, the quintessential securities Supreme Court case was about orange groves, right? Not traditionally securities, but something obviously just about anything can be packaged and sold in an investment contract and thus become a security. So I'm familiar with that lawyerly language and appreciate its necessity. So if we go back to the regulatory ladder and we're trying to climb up from, okay, now we've shifted the vibes. In my view, the next layer up is more formal rulemaking. And that, I think, again, could come from the commission. How do you think we go from, okay, a fresh set of vibes, more momentum, wind at our back, to actually getting toward proposed rulemaking? What are the next steps there?
So you're correct that we need to move to rulemaking, and we've laid the groundwork for that by holding roundtables. We held a series of 5 roundtables, and we also did a request for written comment on around 50 questions. We've gotten some great written input, and we're taking all of that, and we'll be using that to feed into our rulemaking. And it's not just the crypto task force that's working on this, it's the broader commission. We're working with staff across the commission. And then once we get a proposal out the door, people will have an opportunity to comment on that. So I'm really looking forward to this next stage of our work.
I think the type of rulemaking that I am personally most interested in, and the listeners of this show are likely most interested in, deals with investment advisors, and specifically with the custody rule that applies to investment advisors. I think I know from your public statements that you're well versed in the issues that the existing custody rule can pose for registered investment advisors that trade in digital asset strategies, and there's a number of different reasons for that. But I wonder if you could tell us how do you think RIAs that trade in digital assets should think about compliance with the custody rule as it exists today?
Well, first of all, we do welcome people coming to us with specific questions about how the custody rule, challenges they're facing under the custody rule. Um, One foundational question is whether something is actually a security or not. That does affect what obligations RIAs have with respect to it. So I think clarity that we can provide in that area will be helpful. As I've said, I think a lot of the tokens that are out there just don't fit within the securities bucket. Some of them may have been sold as part of securities offerings, but I think many of them now are not. And so that does, I think, affect how advisors think about it. But for those assets that are securities or that, otherwise, advisors want to think about those within a framework under the Investment Advisors Act or the Investment Company Act. Um, I think we want to provide some more guidance around how people should think about qualified custodians. This issue is a bigger issue than just crypto, but I think that's an area. Um, and then we did have a pretty big proposal out there on revamping the custody rules. There was the safeguarding proposal, which got a lot of critical comments from not only the crypto world but kind of across the board. And so that's something that we just need to rethink our approach there and think whether there are particular areas that need to have modernization. I think there's an argument that the custody rules could be modernized, but we should think about how to do that. Within the crypto space specifically, some of the concerns that advisors have raised with me is, look, if we want to be able to assist clients with these assets and there are no qualified custodians, what are we supposed to do? Can we do custody ourselves? Are there some instances in which that might be the better thing? And obviously, the custody rule is there to protect against some pretty terrible potential ways of taking advantage of clients. So we want to make sure that clients are protected, but we also want to think about what makes practical and pragmatic sense in this particular area where there are some unique technological features.
Yeah, absolutely. And I wonder if the way how you think about it, in the sense of, I think one way to address some of the regulatory unclarity with respect to the existing rule is to broaden the scope of who can qualify as a qualified custodian. So maybe that opens up more avenues at which advisors can custody assets with qualified custodians. But I wonder if you think a more fundamental rethinking would be in order, and reconsider whether intermediation is a necessary step for certain assets, or whether there could be a compliant way for RIAs to self-custody certain digital assets. Is that something you think warrants consideration?
Well, I can certainly see the argument for it. I don't know if I would describe it as self custody if you're holding on behalf of your clients, right? So, I mean, I think of self custody as being the client holding for herself. Um, but I see your point, right? And I think that's what some advisors have approached me to say, look, we think there are situations in which there's not actually someone there who can who can provide qualified custody, or there are instances in which we need to be able to have custody so that we can trade it or we can, do things with it. And so I'm open to those conversations. We, of course, need to build in protections to make sure that um, client assets are being protected from bad actors. And so, if people have thoughts about how to do that, I'm certainly open to that as well. And I think regardless of what happens at the SEC, the industry ought to be thinking about this because, again, if some of these things are not securities, there might be a different set of rules that apply, right? But you ought to be thinking about how you can best protect your clients.
Yes, I think that should certainly be the end goal of any, whether it's requirements under applicable rules or whether it's just best practices as an industry. But that's good. That's good to hear. I know when the safeguarding rule that you alluded to a moment earlier was formally removed from the docket. There were a number of additional rules that were also removed, and I think the statement that the SEC released said something like, if the commission intends to provide further rulemaking on any of these topics, it will do so pursuant to, the typical notice and comment process. I'm wondering, is there actively a discussion internally about updating the custody rule again, or is that maybe a future item?
Well, I think it's something that people have been talking about for many years about the potential need to do something to provide an update on the custody rule. So it's something that I'm open to doing, to thinking about. And so if people want to weigh in on whether it should be on our agenda or not, that's fine as well.
And what is the best way for people to weigh in on something like that?
Well, you can come talk to me. You can come talk to the other commissioners. I think the other commissioners also have a very open door policy. And you can talk to the Division of Investment Management, which also loves to hear from people. So I really would encourage, whether it's about this issue or any other issue, I would encourage people to reach out. And, if you think your issue is not, whatever issue it is not getting attention, then put it on our radar.
Got it. Thank you. We will do that. So switching gears a little bit to investor protection, I think you've mentioned in the past that investor protection goes beyond just enforcement, and there's a piece of investor protection that is getting the government out of investors' way and allowing adults to make informed investment decisions with their own money. I think in the crypto world, what I see a lot is that the regulatory uncertainty over the last few years has resulted in a number of industry players avoiding interactions with U.S. persons and essentially prohibiting U.S. persons from, whether it's getting on with their exchange that operates outside the U.S. or buying tokens in a project that's offered outside the U.S. They're essentially prohibiting U.S. person participation. And I think the impetus for that is fear of, being in the regulatory crosshairs, getting a letter from the SEC or the CFTC or however it is. I think the effect of this is that U.S. persons often are kind of shut out of what might otherwise be attractive investment opportunities. And I'm wondering if that aspect of the regulatory uncertainty is something that's on your agenda, and whether you think there's anything the Commission can do unilaterally to help address it.
Well, certainly it's on my agenda. It's something that I've heard a lot about, the frustration that things that people in other jurisdictions are able to take part in, they can't do in the United States. And so I think it is the way you sort of put that question together, I think is right. Investor protection is a complicated thing. A piece of it is protecting investors from bad actors through enforcement actions. But a piece of it is also ensuring that investors have access to a lot of opportunities, that they also get the information they need to make decisions that are best for them and their families. Now, if something is not if something's not a security and it's not a securities offering, we may not have anything to say about what that disclosure looks like. If it is being offered in a securities offering, we do. And so we work on the disclosure in that case. Or something is being offered, if you're looking at something like an exchange traded fund that is under the 40 Act, or an exchange traded product, we're looking at the disclosures, and we're working on making sure that investors get the information they need. But I think the broader question of what can we do to make people comfortable to involve U.S. investors, it's not just a vibe shift, right? It is something more than that. It's saying there is a way for you to offer these products in the United States. But that may require some real legal work on our side, and as well as on the side of the person trying to offer that in the US. And so one message that I have is we are absolutely willing to work with people to think about how these products interact with U.S. securities laws that people are trying to offer, or that they're offering in other jurisdictions, and they would like to offer here in the U.S. We do have a pretty well-developed set of securities laws here. There are some of these issues that come up that are not actually new issues. They're just old issues that are packaged in a new asset class or a new technology. And so come talk to us about what you're planning to do before you do it, and we can probably work through the analysis. We're not going to be your lawyer, but we're certainly happy to work through the analysis and discuss with you how that might work. So I think it's going to be a process, but I do want people to make products and services accessible to people in the U.S. So I think we're all working toward the same goal.
That's great. And I totally agree with you the way you described that. I think in reality it's going to take a pathway for these entities to register under some local status and get a license locally so that they can have the comfort that what they're doing is not gonna violate not just securities laws, but also that, if a new SEC comes in and the vibes shift again, they'll have some assurance that they're on the right path. At least they're on the right regulatory path.
Yeah, and I mean, I think the best thing that we can do is really get a good framework within which products and services can be offered, and then then you can show the world what these products and services can do for the people buying them. And if you're making that case in a way that, if people are embracing these products and services, then it becomes harder for a new administration to come in and say, well, we don't want people to have access to these anymore. I think one unique feature in the United States, we have a pretty complicated financial regulatory framework with federal regulators, and then at the federal regulatory level, you've got the SEC and the CFTC. And some products fall within the CFTC's regime, some within the SEC's regime, and so that's something that people are going to have to think about too. They may not have to work with just one regulator, but may need to work with multiple regulators. And so some of this work can be quite painstaking, but I think it will be worth it at the end of the day to get that regulatory clarity, not only for the product issuer, but also for the people buying those products so that they understand what the protections are that apply not only to the sale of the product, but if something should go wrong, what is the status if there's a bankruptcy, or if something else bad happens, what are the protections available? So I think it can be at the end of the day better for everyone if they know what protections are actually covering them.
Completely agreed. And you alluded in that answer to the sort of there's the CFTC that regulates certain products, the SEC regulates other products. I think there's been some high profile discussions out there about, where does crypto fall in that universe? And I guess I was wondering for your view, I think you alluded to it a little bit earlier when you said, certain digital assets might have been initially offered and sold in securities, but over time have reached a point where they're probably no longer being sold as securities. Do you think that is there a role for the commission to set out some of these lines more clearly itself? I guess that would be through notice and comment rulemaking, or do you think it's really Congress needs to set those lines and then the commission can set up rules within those broad outlines drawn by Congress?
No, I mean, I think we should use our existing authority to provide some guidance to people who are wanting to offer tokens in a securities offering, and provide some guidance to them about how that would work. So I think that is something that notice and comment rulemaking can do. Congress is working; both the House and Senate are working hard on crypto legislation, which is wonderful, and I think that will help to provide long-term clarity about where the authority needs to lie, around some crypto tokens, around how they trade and things like that. But I think the reality is we already have quite a bit of authority, and that's authority that we can flesh out through regulation.
Do you see that? Do you see that happening in the relatively near term with more assets? I mean, I think the meme coin statement is kind of similar. It obviously wasn't a notice and comment rulemaking, but I think the commission has exercised its authority in some ways to make it clearer what is a security or what is not a security. Do you foresee more of that happening in the relatively near term?
Yeah, again, I think what I'm hoping that we can do with notice and comment rulemaking is lay out clear pathways that people um, can you know marry capital raising with token issuances, and so I think that's what's what's been people have not been able to figure out how to do that. And so I think that's an area we can work through in notice and comment rulemaking. Many years ago now, I put out a safe harbor proposal for what it might look like to offer crypto assets, and what the disclosure framework might look like. And so I think those kinds of issues are ones that we're thinking about. The first roundtable that we had was around the definition of security and how that applies in this space, and I think some of those themes are ones that that we can work into a rulemaking as well.
Great. And when we think about legislation that may or may not happen, we know Congress obviously is working on a number of different things. Do they consult you or the commission more broadly when they're working on legislation like this, or do they operate more or less independently? Are you involved at all in the crafting of legislation at Congress?
Well, the crafting is theirs, and I really I admire the ability of the staff to take on these issues because they're not easy issues. Legislation is very difficult to write because you want something that really stands the test of time, and so they're working very hard on that. And I really admire that they do consult us for technical assistance, and we work with them to provide technical assistance. But ultimately, the product is theirs because they've got to. They're the politically accountable ones, so they've got to make the calls on where authority goes, and that's appropriate. And we look forward to working with whatever framework they come up with, and we look forward to working with the CFTC as well as other regulators across the system.
So I know we're kind of coming up on our allotted time here. I just have one final question for you. How do you feel about the title Crypto Mom?
Well, I think it's kind of a funny title to have. I'm not sure everyone, some people have taken that title away from me because they think I am mean. But I think, on the serious side, I think it is really important not to think about government or government officials as being parental. This kind of goes to a core philosophy that I have, which is that the wonderful thing about the United States is that we're a country built on the idea that individual human beings are fully capable of making decisions for their own lives, right? So adult human beings should be able to make decisions for their own lives. And we live in a society that cherishes that ability and that really pushes back when government tries to step in and say, no, we're going to, treat you like a child and tell you what to do. That the American spirit says, sorry, that doesn't work for us. And so, we do as regulators have a role to play. And where Congress has told, going back to what we were talking about before, Congress gets to tell the regulatory agencies what to do. But often Congress gives us pretty wide latitude in thinking about how to actually effectuate the directives that they give us. And so one of the principles that's really important to me in effectuating congressional directives is maximizing the ability of individual human beings to make decisions for their own lives. And so I think the name is funny, but I do want people to know that I'm a big believer in individual decision making. And obviously, with that goes the fact that when you make bad decisions, you can't come crying to mom. You got to take responsibility for those decisions too. So that's kind of how I think about that.
Well, I love that. And I think that ethos runs through a lot of your public commentary. And just to touch on one point you made, having met you in person and now virtually, I can attest that you are not mean. And so that criticism should fall away.
Well, Dave,
Commissioner Peirce,
thank you so much for having me.
Thank you so much. It's been a real pleasure chatting with you, and I hope we cross paths again soon.
Sounds great. Take care.
Thanks for listening to Tokens of Wisdom with Dave Rothschild. I hope you enjoyed this episode. Please like, follow, and subscribe to our show wherever you get your podcasts. Well, now that all that boring stuff's out of the way, it's time for the part you've all been waiting for. The legal disclaimer. In this show, I describe laws and regulations from a 10,000-foot view. And while this should be obvious to most, I need to say it nonetheless. This show is for informational purposes only, and nothing I say here constitutes legal, investment, or tax advice. If you're thinking about starting a fund or you're curious about your options, this show is a good resource. But if you're going to pull the trigger and launch a fund, please engage an attorney to assist you.